My name is James Murphy. We're going to chat for a while about the selection of witnesses and the preparation of Rule 26 reports. This section of the slide presentation summarizes concepts central to an attorney's decision-making in the selection, vetting, and retention of an expert witness. At the outset, let's recognize that there are different categories of expert witnesses. Care should be taken early to ensure that if an expert opinion is needed, the right expert is identified and retained. This segment also discusses counsel's obligations for timely disclosure to opposing counsel and the court. Do I need an expert? In every case of any substance, counsel should first ask, do I need an expert? This is not always an easy question to answer. The recent July 3, 2018 Rhode Island Supreme Court decision in Rhode Island Resource Recovery, Inc. versus Restivo Monticelli, LLP is a case in point. Although the plaintiff in that case supplied testimony by certified public accountants on the issue of liability and damages, the Supreme Court reversed, holding that the defendant was entitled to judgment as a matter of law because plaintiff failed to prevent expert testimony on the issue of causation. This case is a must-read as you begin contemplating whether or not to retain an expert. Some tips. First, determine what the issue is in your case. Identify and then drill down, looking at how the issue relates to a breach of duty, causation, damages, etc. Next, look at the Federal Rules of Evidence, especially Rules 701 and 702. State rules are likely to be at least slightly different. Read the case law on the issue of experts as it may pertain to your case. Know your judge. What does he or she tend to require? And ask around. Also, ask yourself if yours is a case in which lay witness testimony or another party's expert witness can suffice. Can a non-expert provide admissible and credible testimony on the issue? Sometimes no expert is your better choice. Consider, do you need an expert to prove your case or to disprove your opponent's? Sometimes a well-designed and well-prepared cross-examination of an opposing witness is better than presenting a counter-expert. Sometimes you can even make the opposing expert yours. Remember, the rules of evidence require an expert's opinion to be based on scientific, technical, or other specialized knowledge. The real touchstone is whether your expert's testimony will assist the trier of fact. Or is it an issue on which the jury can reach a collective opinion that results from a process of reasoning familiar in everyday life? Sometimes we call this common sense. The gatekeeper, of course, is your judge. Lastly, try to foresee if opposing counsel, or the court itself, will see your expert's opinion or methodology as novel or controversial, thus triggering a Daubert or Kumho-Tyer or DiPetrillo motion and hearing. In essence, a good expert is a persuasive teacher. Of course, Federal Rule of Evidence Rule 702 is more technical and generally limits testimony in the form of an opinion to a witness who is qualified as an expert by knowledge, skill, experience, training, or education. There is more here than simply a base formula for qualifying an expert. There also is the variable of perception by the jury. An expert can only be as effective as his or her academic education, professional training, years of experience, and charisma will allow. For a trial lawyer, I suggest an expert is a person upon whom you can rely to teach you in your role as an attorney for the party. You and the expert become a team. Only then should you seek to present the expert to the judge and jury. For your case to be successful, they must see your expert witness as someone who is credibly teaching them about complex and possibly controversial things they likely would not otherwise understand. There are nearly limitless trial issues for which expert testimony is suitable. Medicine, engineering, accounting, motor vehicle accidents, environmental pollution, each may engender the need for expert witnesses at trial. Whatever the area of expertise, your expert should assist you in becoming an expert yourself, at least within the narrow issue that your case presents. But there are other types of experts to consider. These include professional experts, occasional experts, and accidental experts. Also, we must deal with the categories presented by Rule 26, which are retained testifying experts, non-retained testifying experts, and non-testifying experts. Professional experts include retired academics and forensic consultants who devote a substantial amount of their time to providing expert services to attorneys. These are the regulars, either in the local jurisdiction or nationally. Professional experts, however, come with their pros and cons. Among the pros, they frequently testify and often have teaching ability. They possess robust CVs, which often are supported by journal articles and scientific research studies. They usually are comfortable in deposition and at trial and have jury savvy. These experts can be very helpful in identifying issues and in developing your own cross-examinations. They also are usually comparatively easy to find because they often have a well-developed track record. Among the cons, for some of them, their pride or ego outweighs their jury savvy. Their well-developed track record may include transcripts of prior testimony and professional writings that are impeachment baggage or at odds with the testimony they will give in your case. Also, if they tend to testify only for plaintiffs or only for the defense, professional experts are vulnerable to claims of bias and inconsistency. If they advertise, this may become a liability. Also, they tend to be expensive. On the other hand, occasional experts are retained more infrequently. Being an expert witness is not a major part of their lives, but because they devote their professional lives to a narrow subject area, they possess a unique and distinctive expertise that makes them uniquely qualified for a certain particularly unusual case. They can be board-certified physicians, registered professional architects, CPAs, and even lawyers. Perhaps they wrote the definitive book on the issue your case presents. The occasional expert witness you may need is often difficult to find, but may charge less, and they are often less vulnerable to claims of bias and may have a shorter paper trail. A third category is what we can call accidental experts. These men and women may be employed by a party or by a third party involved in the product or the project giving rise to the case. They may have been involved in the post-accident investigation or remedy, and therefore have the specialized knowledge relating to the subject matter. For example, a police officer may, or may not, be in a position to provide expert testimony on a matter he or she investigated, as compared to the retired police officer expert who had no involvement in the incident but is an expert. Other examples of accidental experts include a medical examiner who performed the autopsy, a chemist who analyzed the substance, or an environmental engineer employed by a governmental agency with respect to remediation of pollution. These may be non-retained accidental experts. There also is another three categories of expert witnesses. These are created by Rule 26. Otherwise stated, they are, first, retained testifying experts and those retained or specially employed to provide expert testimony in the case, or one whose duties as a party's employee regularly involve giving expert testimony. These are Rule 26A to B experts. Second, non-retained testifying experts. For example, these include treating physicians or accidental experts. These are Rule 26A to C experts and are treated differently with respect to disclosure requirements. Finally, there are non-testifying experts. These include consulting experts and non-testifying, non-witness employees with knowledge. Although they will not testify and the jury may never even hear their names, they can be invaluable in educating you and assisting you in preparing for the depositions and cross-examinations of the opponent's experts and other witnesses. As a general rule, they are not disclosed. You have decided you need an expert, and you know the issue for which you will need an expert opinion. Now all you have to do is find one. Sometimes it is easy. You or your firm or your client may already have a go-to orthopedic surgeon or accident reconstructionist that you have retained successfully in the past. Other times, you may as well be searching the haystack for the proverbial needle. Your research skills, your contacts, and your time are your best allies. Here are some tips. First, try narrowing your search criteria, especially if you have too many names on your list. What is it exactly that you need your expert to do? Second, utilize available resources for finding your expert. In other words, ask your colleagues and your mentors. Use the phone. Ask your client and others familiar with a particular business, industry, or profession in issue. Ask them if they know who knows. A Westlaw or Lexis or other database search on the expert-related issue you are facing may tell you who is the national go-to expert on repressed and recovered memory syndrome, for example, or what expert most frequently takes the opposing view. Similarly, Google searches and professional journal archives can lead you to the experts who publish and speak most frequently on your issue. Also, you should refer to available professional organization directories, expert directories, listservs, and databanks. The Rhode Island Association for Justice and the Defense Council of Rhode Island both have expert databases and the ability to forward your inquiries to their members. Both organizations also have national affiliations with even broader expert databases. Third, once you have a manageable number of prospects, you must carefully and fully investigate each of them. The vetting process is indispensable, or you may end up like the gentleman in the cartoon. In vetting of experts, check their prior cases and pronouncements. Investigate your own expert as if he or she is your opponent's expert and you are preparing for cross-examination. Has this expert been slammed, praised, or even barred? Call other counsel who retained and who cross-examined the expert. Obtain transcripts of the expert's trial and deposition testimony. You can be very sure that your opponent will. Read the expert's publications, especially on the topic in issue. See if you can get prior Rule 26A to B reports. Scrutinize the expert's curriculum vitae and check everything. Is there a gap in the resume? Why? Find out. Fourth, is the expert witness available? Available locally? Is his or her schedule open? Can you get meetings with this expert? Will it be available for trial and deposition? You have to know this at the outset. Fifth, is the expert you are considering qualified? Sure they're qualified, but are the qualifications of premier quality? Juries carefully weigh the qualifications of one expert against another. It is not good enough simply to get your expert through the judge's gate. You also need to convince the jury. The early bird catches the expert. Start your expert witness search process early in the case, if possible even before the pleadings. The earlier you start, the earlier you will learn, possibly even that you have no case. Consider the funnel approach, starting broad, gathering data, and then narrowing your search and winnowing to the right expert for your case, its particular issues, and its unique circumstances. Hold a Best in Show contest. That means personally interviewing your short list of candidates, preferably eyeballing each in person and with your team present. Evaluate physicality, diction, nimbleness, and poise. How will a judge and jury perceive your expert? Find out if your expert understands the legal requirements of proof, the standard of care, what reasonable degree of medical certainty means, and what is required for an opinion to be admissible. Is he or she teachable on the nuances of litigation? Can the expert teach you? Most important, can you work together? Be prepared to question the expert as if you are cross-examining. Explore the expert's weaknesses. Ask the tough questions now. Is the expert articulate? Dissembling? Does he make eye contact? Does she stand her ground? Test early on for whether there may be an expensive and potentially dispositive Daubert, Kumho-Tyer, or DiPetrillo challenge to your expert and the opinion. Ensure that you and the expert understand what is confidential and what may be required to be disclosed. When you and your client have selected your expert, carefully draft the engagement letter in concert with your expert. The expert may well be cross-examined on it. The jury may see it. The same caution must be exercised with respect to the expert's Rule 26A to B report. Avoid the expert for all seasons. Sir Thomas More not only is the patron saint of lawyers, he also is renowned to this day as a foremost Renaissance man. His multifold skills were impressive, but they did not save him from fate. Your expert witness should not be a modern-day Renaissance man or woman. Prefer an expert who is uniquely qualified to convincingly convey a narrow point on a single area of expertise to the jury. If you can, avoid the expert who professes to know everything in his or her field, or who is a know-it-all and inflexible in the face of contrary facts, data, or opinions. Find this out during the Best in Show contest. Is the expert an all-plaintiff or all-defense witness, or, in the language of our profession, a hired gun? Does the expert personally advertise in plaintiff or defense or general litigation publications? Which ones? What do his advertisements say? What do other experts and attorneys have to say about her? Find out early and incisively if your expert can withstand and then credibly rebut the slings and arrows shot at him by others. Seek the expert whose expertise focuses on the narrow issue you have, not one who claims expertise across a broad spectrum of medicine, engineering, law, etc. For example, in an estate planning legal malpractice case, would you choose a criminal defense lawyer, a zoning lawyer, or a domestic relations lawyer as your expert? Remember, expert witnesses, like lawyers, are not fungible. They are each unique. Your job is to find the best one for your particular season. Follow the rule. It sets out precisely what the expert disclosure and report require under Rule 26A to B. Also, check your local case law, pretrial order, and local rules updates. Rule 26 disclosure requirements should be addressed upfront and early with your proposed experts. In state court, check what rules, if any, govern expert disclosures. Rule 26A to B covers retained experts and those who are specially employed to provide expert testimony or whose duties as an employee of a party regularly involve giving expert testimony. But even if an expert witness is not required to provide a written report, Rule 26A to C nevertheless may require a disclosure by you of the expert's testimony and subject matter and a summary of the facts and opinions to which the expert is expected to testify. The Rule 26A to D1 general deadline for submitting your expert disclosure is 90 days before the date set for trial. Evidence to contradict or to rebut expert evidence must be disclosed within 30 days of the other party's disclosure. Supplementing of disclosures is governed by Subpart E. These deadlines are critically important. Be sure to coordinate with your expert, your client, and your key witnesses in preparing the report to ensure that it is complete, methodologically sound, factually supported, and does not conflict with other aspects of your case. In the process, test it for vulnerability to cross-examination, motions in limine, Daubert-Kumo di Petrillo motions, and potential objections. Lastly, in doing this, do not let an error or a non-disclosure on your part become the Achilles heel of your case. So, what goes into the disclosure? Rule 26A to B is straightforward, and it provides a detailed checklist of specifically what must be contained in the expert witness disclosure. According to the rule, unless otherwise ordered by the court, all disclosures under Rule 26A must be in writing, signed, and served. Also, the disclosure must be accompanied by a written report prepared and signed by the expert, if he or she is a retained expert, or a specially employed person, or a party's employee expert. The report must contain A complete statement of all opinions the expert will express and the basis and reasons for them. B, the facts or data considered by the witness informing the opinions. C, any exhibits that will be used to summarize or support the opinions. D, the witness's qualifications, including a list of all publications authored by the expert in the previous 10 years. E, a list of all other cases in which during the previous 4 years the witness testified as an expert at trial or in deposition. And finally, F, a statement of the compensation to be paid for the expert's study and testimony in the case.
My name is Peter Cirilli. I am a Providence lawyer practicing with the firm of Foley Cirilli, and my portion of the presentation is preparation of expert witness for direct testimony. A thorough and detailed preparation of the expert witness can take considerable time, but it is essential to make sure that the attorney and the expert are speaking on the same page, that the expert is comfortable in testifying to the opinions, and that all evidentiary requirements for admissibility are satisfied. The more time spent with the expert in preparation, the smoother and more persuasive the expert testimony is likely to be. Pretrial preparation of the expert witness is critical to a successful trial and must be accomplished during a meeting held well before the trial begins. The attorney must make sure that there is adequate time for a thorough working session with the expert. The time to learn of the expert's degree of confidence in the opinions to be offered must occur before and not during trial. The attorney must know the exact substance of the expert's answers. The expert must know and be comfortable with the outline of questions he or she will be asked. Question the expert on the degree of confidence and certainty in the opinions. Ideally, this is fleshed out at the time the expert is retained, but the passage of time or consideration of additional evidence can alter an expert's views. A frank discussion with the expert during the pretrial meeting can avoid potentially damaging trial testimony on direct or cross. The attorney should explain to the expert the requisite degree of probability required for admissibility, and the expert must be comfortable to use such phraseology. If there is any uncertainty or reluctance on the expert's part, such issues must be addressed and resolved now during the working session, because otherwise may be reflected in the expert's presentation before the fact finder. For instance, the expert should understand that opinions generally must be stated using terms such as probable or more likely than not. Make sure that the expert is intellectually comfortable with that degree of certainty and using the requisite phraseology. Qualification of an expert witness at trial is a technical evidentiary requirement. However, it is much more than that. A good qualification can lend greater weight to the expert's opinion. Qualification testimony can also be used as a persuasive teaching method for the fact finder regarding important issues in the case. Use the opportunity in preparation of the expert witness to construct a qualification direct testimony that will educate and persuade the fact finder regarding the weight of the expert's testimony. Using the expert's CV as a framework, explore whether the expert has any particular experience or publications germane to the issues in the case. Prepare questions for the expert to highlight such experience and select publications that are relevant to the case issues. Construct a direct examination that persuasively uses the expert as a teacher to educate the fact finder regarding terminology, technical issues, science, and the fields of study that are germane to the issues in the case. Work with the expert to identify helpful demonstrative exhibits and visual aids that can be used as teaching tools for the fact finder. Most importantly, make sure that the expert is prepared to testify in a manner that is comprehensible to the fact finder. This can be a challenge with some experts who are so ingrained in using their own special vocabulary. Spend time to make sure that the expert's testimony is comprehensible to laypersons. Otherwise, it will have little persuasive weight. The most important part of preparation of the expert witness is directed towards the actual opinions to be solicited at trial. Make sure that the expert understands the scope of the subject matter of his testimony, and importantly, that the testimony remains within the contours of the expert disclosure. Go through the actual expert disclosure with the expert. Keep in mind that undisclosed opinions and supporting facts may be excluded at trial. The expert should understand this, and the expert should understand the admissibility perils which may arise if he or she strays from the contours of the disclosure. Identify and review each and every opinion to be elicited, and again, ensure that the expert's opinions are stated with the requisite phraseology, such as, to a reasonable degree of probability. Construct a direct examination that ensures the expert opinions are admissible under Federal Rule of Evidence 702 and under the Supreme Court's opinions in Daubert v. Merrill Dow Pharmaceuticals and Como Tire v. Carmichael. While constructing direct examination, it may be helpful to refer to the actual Federal Rule of Evidence 702, which sets forth the evidentiary requirements for admissibility. Use the rule as a framework to ensure that the ultimate opinions offers will be admissible at trial. First, prepare questions which elicit the pertinent facts or data which the expert is relying upon. Secondly, ask the expert questions about the methodology and principles he or she is applying in forming the opinion, and whether these methods and principles are generally accepted within the community or field of study. Finally, ask questions designed to demonstrate that the expert has applied those same accepted principles and methodologies to the particular facts of the case. The second requirement of Rule 702 is to demonstrate the basis for the expert's opinions, and specifically that it is based upon sufficient facts or data. In order to accomplish this, question the expert as to the universe of all documents he or she is relying upon, the literature, studies, tests, data, and reports. Keep in mind that an expert may rely upon documents that are not themselves admissible in evidence. Agree with the expert on a list of all of the documents relied upon. And at the time of trial, at the very least, the expert should have the agreed-upon list of all documents. It may be helpful to select certain documents to which the attorney will draw the expert's attention and develop the expert's commentary as to each such document. This ensures a persuasive examination which satisfies the evidentiary requirements. Work with the expert to construct a direct examination that will demonstrate that the expert's conclusions were reached by methods consistent with how their colleagues in the relevant field or discipline would proceed. Ask the expert whether the procedures and methodologies he and she used are the same as those followed by others in the field. For example, The process of making a differential diagnosis is a common method followed by physicians in medical cases, or projecting profit or loss in economic cases are traditional methods that experts use in their respective fields. After establishing that the expert is following commonly accepted methodologies, guide the expert through the step-by-step process he or she followed in analyzing the specific facts and data in this particular case. Ask the expert how he or she reached conclusions supporting the opinions to be offered. The most important part of preparation of the expert witness involves review of the actual specific questions designed to elicit the operative opinions in the case. The attorney and the expert must know precisely what opinion questions will be asked and the exact form of the opinion question. Walk through a sample line of questioning with the expert as to each opinion. A typical format for the line of questioning is as follows. After your review the facts and data in this case, what facts and findings did you make? What data did you rely upon in forming your opinion? How did you apply standard and reliable methods to those facts and findings? Do you have an opinion to a reasonable degree of probability as to the particular relevant issue in the case? Finally, what is that opinion? With a corollary question, explain that opinion to the jury or the fact finder. Repeat this line of questioning for each relevant opinion. It's important that you walk through these lines of questioning with the expert because the elicitation of the ultimate opinions in the case is critical to successful prosecution of a trial.
My name is Mark DeSisto. My portion of this presentation is for the cross-examination of an expert. I'd like to start with the fundamentals of general cross-examination which apply to experts, and here are three general rules of cross-examination to use. The first one is don't. And by that I mean don't cross-examine just to cross-examine. You usually do have to cross-examine a witness, and especially an expert, but limit it to the areas that will help your case. The second rule is anticipate. Sometimes you hear don't ask a question unless you know the answer to it. I think it's best to anticipate every possible answer and then make a determination based on those possible answers whether or not you want to ask a question. But you should be able to anticipate any possible answer from, in this case, the expert, and be prepared to address that. It's like baseball, where the first baseman is thinking, what do I do if the ball comes to me? And the third baseman is thinking the same thing, and the outfielder is thinking, what do I do if the ball comes to me? Well, when you're cross-examining, you're fielding all positions. What am I going to do based on any particular answer? And that's the fun part of preparing, figuring out, anticipating, and being prepared for it. All right, the last general rule of cross-examination is to be fair. Jurors don't like unfair questions. They don't like it when you cut off a witness, be it an expert or a lay witness. I tell the young lawyers in my office, and the person who helped me put this together, Pat Burns, who's going to be a good lawyer, he's in law school now. When you're a trial lawyer, we conquer not by force but by persuasion. Don't try to overpower any witness, including an expert. You're not there to overpower a witness. You're there to persuade the jury. When you prepare for cross-examination of an expert, the first thing you should think about is, what's the purpose of the cross-examination? What do I want out of the cross-examination? Usually it's to neutralize the witness. Sometimes it's to gain an advantage, or sometimes you want to create a foundation for your expert, or all three of those. But you've got to know your purpose ahead of planning out your cross-examination. That will dictate your manner and style. For instance, if you have just one area to neutralize an expert, you may want a quick pace. Or if you have a number of areas where you want to create a foundation for your expert, that may mean that you want to slow the pace down and you may want to highlight certain areas. But it's very important to decide prior to drafting out your outline of cross to determine the purpose. Once you determine the purpose, you can begin to prepare, and obviously you have to do your homework, as you have to on all parts of the trial, but it's important to gather as much information as you can on the topics that you are going to cross the expert on, and for instance, corroborating the expert's CV or looking for depositions in prior cases that the expert testified to. It's also important to ask your own expert how she or he would cross, or what questions to ask. Utilize your own expert. It can be very helpful. When preparing the cross of an expert, there are 3 topics you can look at to cross: protocol, credentials, and substantive matter. You should keep in mind that experts are prepared on the substantive matter, what they're there to testify to. They're prepared on their credentials, and frankly they know more than you, or should know more than you, on both of those topics, substantive matter and credentials. They're expecting the cross on that. So it's good to start with the protocol, and by protocol I mean, how is it that they arrived at their opinions? You'll find that that's the most fertile area for cross-examination. So let's focus on the topic of protocol for cross-examination for the moment. It's important to get the witness to talk about how she arrived at her opinion. And when you do that, you're creating topics for cross-examination in areas where you're on an equal footing or better footing than the witness. You can ask the expert what guidelines or principles that the expert used in order to formulate her opinion. For instance, professional integrity. Of course the expert used professional integrity. Accuracy in reporting what she has done, because any expert will agree that she needs to be accountable for how she arrived at the testimony. Once that occurs, you have some grounds for cross-examination. How was the information gathered? There are 2 commitments to get on cross-examination of an expert that are most important. The first is that the witness understands and agrees that she or he needs all of the available information to form a valid opinion. The next one is that there was some sort of a process where the expert discarded unreliable information. Once you have those commitments, you can cross on whether or not all of the information was received by the expert, and what the expert considered to be reliable or not reliable. And generally, experts use the testimony of the party that they're representing and find that to be reliable, and that's where you want to cross-examine. The next topic of cross-examination is to cross on the credentials of the expert. This is dangerous, but it can be effective in some cases. Don't cross on the expert's credentials unless you absolutely need to, and unless there is a topic upon which you can make inroads. There are 2 key areas that may be applicable. First, you can match your expert's credentials against the other expert's credentials. For instance, if your expert is a board-certified physician and the other expert isn't, you can ask that expert on cross what that is, and the fact that he's not or she's not board-certified. Sometimes there's a clinical experience that the expert witness is lacking and your expert has it, and so you'd want to cross on that. But generally, it's dangerous to cross on credentials unless you absolutely need to and you have something to cross on. The final topic for cross-examination is to cross the expert on her substantive matter. Now, you're in the expert's arena. This is dangerous. If you try to debate the expert, you're going to lose. So You should know what the expert that you're crossing's opinion is as opposed to your own expert. You should look to clarify what that expert is saying and to restrict the opinion. And also, as I said earlier, you should look to make it conditioned on facts that are in dispute. It is very easy to want to engage in a debate with an expert to show the jury how much you know. That's the wrong thing to do. One of the most important parts of crossing an expert is to know when to stop. And this goes back to your purpose. As soon as you make your points, you should stop. Don't be greedy. If your purpose is to neutralize the expert and you think you've been successful, then you should stop. Stay with your purpose. Mark Mandel is an attorney, and like others who cross-examine experts very well, if you ask him how he did on his cross of an expert, the first thing he brings up is discipline, whether or not he was disciplined. Did he stay within the topic? Did he stay with his purpose? And did he end when he should have ended? And that's what you should do. You should be disciplined and stop when you've neutralized or you've reached the purposes of the cross. The final point is to cross-examine the expert for a foundation for your closing. You should generally know how you want to treat the expert in your closing when you're preparing for the cross-examination. You want to be able to refer to the expert's cross or some of the commitments you receive from the expert in your closing. Generally, it's good to be able to say to a jury in closing that that jury knows more than the expert does, because the jury can consider things that the expert could not, and you can ask the expert that on cross. For instance, sometimes an expert uses just the medical record and can't consider the testimony that came in at trial and so forth. You want to be able to ask the expert this on cross, what was relied on, what wasn't, and then go back in your closing argument and point out that the jury can consider things that the expert could not. So keep in mind that eventually you're going to have to close to the jury, and you want to be able to bring up some of your cross, if it's successful, in that closing.
Thank you for viewing the Litigation Academy Expert Witness Examination Program PowerPoint presentation. We look forward to seeing you on October 10, 2018.